Thank you so much for this kind introduction. And I'm seeing, I think Bayomi's screen is still being shared, but I can start introducing while he removes it. Okay. Thank you so much. All right. So today I'm going to take you through simple rules of arbitration. I think Abayomi has actually explained a lot of things which are basic rules for arbitration. And I will take you through the practice of institutional arbitration, particularly with respect to the Nairobi Center for International Arbitration, and also just to explain a little bit about the practice of arbitration in Kenya. So let me share my screen right now. Oh, sorry, just hold on a minute. There you go. As I have been humbly introduced, I'll just take you ahead and just talk about the arbitration practice in Kenya and under the rules of the Nairobi Center for International Arbitration. Now, I'll start with basically what is the legal framework for the practice of arbitration in Kenya? What is anchored under that aspect? Now, the practice of arbitration in Kenya is anchored on the Constitution of Kenya 2010. And I think any kind of the practice of law is usually anchored under the Constitution, and then there's legislation that governs thereafter. And then we also have the Arbitration Act of 1995. So the constitutional underpinning the practice of arbitration, sorry, let me just take you back. Yeah, so what aspect of the Constitution governs the practice of arbitration in Kenya? We have Article 159(2) of the Constitution of Kenya, which gives the judicial authority to the practice of arbitration. What is judicial authority? We have three arms of government. We have the legislature, the judiciary, and the executive. The judiciary now is with the courts. Now the Kenyan courts have the mandate to exercise the practice of arbitration, and this I just explained under Article 159(2), which talks about the judiciary will promote the practice of ADR in terms of reconciliation, mediation, arbitration, traditional dispute resolution mechanisms, and etc. And I've just mentioned there's a constitutional underpinning with the use of arbitration in Kenya, and let me just mention Article 2.6, and which you'll understand later in the slides that I'll explain. So any treaty or convention that is ratified by Kenya will form part of laws of Kenya under the Constitution. So which means that even any law that we have ratified using the legislative process, going through parliament, and then it becomes law, then it becomes laws of Kenya. And I'll explain, and you'll understand that when I go to the next slides. So I've just talked about the Arbitration Act of 1995. It came into force in 1995. It was amended in 2010, just a few amendments. And this Arbitration Act applies to both domestic and international arbitration, and it governs proceedings on challenging and enforcement of arbitral awards. So this act adopts the UNCITRAL model law. UNCITRAL model law is usually, which was provided under the UN structure. And this is actually what the law that many countries have emulated in terms of the practice of arbitration. So Kenya is no different. We took up the UNCITRAL model law and we enacted it in our act. So Abayomi actually has explained all this: competence, the standard of impartiality and independence of arbitrators, equal treatment and general duties of our parties, the setting aside of an award, under this particular section. So these are the specific sections of this act that emulate the UNCITRAL model law. It is a model law that many countries have emulated. So even if you go to Nigeria, you go to Tanzania, you will see similar provisions of the Arbitration Act or arbitration laws. So I have just mentioned the Curio law, like the law that we are governed under is under the UNCITRAL model law. That is in Kenya. Now, going back to Article 2.6 of the Constitution of Kenya, where I was talking about the ratification of once a foreign law or a treaty or a convention is ratified, it forms law, the parts and parcel of the laws of Kenya. here comes the NEO Convention, the NEO Convention on the Recognition and Enforcement of Arbitral Awards, otherwise known as the NEO Convention, which came into force in 1958. Now, on 10th February 1989, it's when Kenya ratified the convention. And what does that mean? It means that the NEO Convention forms part and parcel of the laws of Kenya. And this NEO Convention is on the recognition and enforcement of foreign arbitral awards. And I think I saw a question that someone had asked where there's, I think there was a dispute, and then you want to enforce it. There's a dispute which was decided in Kenya, and you want to enforce it in Tanzania. Then what happens? If Kenya and Tanzania are both signatories of the NEO Convention, then, and you want to enforce it in Tanzania, you can freely enforce it in Tanzania, because Tanzania, as a signatory, or actually as a signatory to the NEO Convention and having ratified the same to become part of laws of Tanzania, then it means that they can recognize and enforce arbitral awards from Kenya. So probably the only reason that you would want to, the only question that you would want to ask yourself is, why am I enforcing it in Tanzania? Maybe you want to enforce it in Tanzania because there's a property in Tanzania owned by that person who has lost in the arbitration. That's why you would want to enforce it. But you don't want to enforce it in a country that you would not really be able to execute the arbitration, or actually rather to get monies from what you've won in the case, simply put. Now, having spoken about the legislations that we have in Kenya, then you want to also ask yourself, what is the judicial attitude towards arbitration in the country? And from the jurisprudence, rather the cases that have been put before court, then you will be able to determine how is Kenya looking at the practice of arbitration. And from the cases that have been decided from the High Court to the Supreme Court, we have seen so far so good that Kenya has adopted the minimalist, non-interventionist posture. Which means, what does this mean? It means that the judicial system in Kenya provides for an arbitration-friendly ground, and it is a pro-enforcement judicial approach. And this is actually it doesn't come out of nowhere. It is actually catered for under the Section 10 of the Arbitration Act, which provides that no court in Kenya will intervene in matters governed by the Act. The Act provides for all the proceedings of arbitration. So in that sense, that means that I don't know if you have had experiences before, maybe you can put it in the comment section. If you have a contract and you place your case before a court, and the contract clearly states if ever there's a dispute, the dispute will be sent to arbitration. The court will actually stay the proceedings and tell you to go ahead and do the arbitration first, and after the arbitration has been completed, then you can come to court probably for enforcement, or maybe there was something with arbitration that didn't work out, but they will actually ultimately direct you to arbitration. And the courts have not been silent about this. I'm just going to give you one example, the Supreme Court petition number 12 of 2016, a case between two parties, Newt Agrovet and Airtel. So in that case, the courts raised out the salient features of the practice of arbitration, and because there was a huge debate about the Court of Appeal jurisdiction in arbitration matters, or the High Court jurisdiction on arbitration matters. What happens? Can you appeal an arbitration? What is the finality of an arbitral award? And the court made clear in the following issues. So judiciary affirmed the place of arbitration in the Kenyan legal system, that arbitration is recognized as one of the ways of solving disputes. Number two, it affirmed that the UNCITRAL model law that I've just explained is the basic framework for the Arbitration Act of 1995. Number three, that the judiciary regarded that it's good to acknowledge the best practices that is happening in the field of arbitration. There's always a trend. There's always a new way of doing things. Maybe I give an example probably about third-party funding, whereby there's an arbitration, and then the person is not able to raise funds for the arbitration process. Then you seek a third person to fund your process so that you can have your matter heard in arbitration. So those are some of the progressive things, like for example, in UK, Canada, and Singapore, that that the judiciary regards as the best practices. Now, another one, the judicial precedents entrenching a minimalist approach. So this is where the Supreme Court pronounced itself and said, us as the judiciary, we have had a myriad of precedents that we have a minimalist approach towards the arbitration process, which means we do not want to engage ourselves in the field. We do not want to be in the arena of the arbitration process. And now it said in itself that, and as the Supreme Court of Kenya, we will not be indulging in such aspects. So long as the contract itself is not conscionable, so long as the contract itself is valid, then I don't see a reason why we should be interfering with the arbitration process. Now, having spoken about, the arbitration practice in Kenya, what laws govern the arbitration practice in Kenya, and also what the judiciary has said about the practice of arbitration, then I'll go ahead and talk about the practice of arbitration and the NCIA arbitration rules. Probably I just give a brief background about whom I just mentioned it a few. The Nairobi Center for International Arbitration was formed under Nairobi Center for International Arbitration Act of 2013, number 26 of 2013. And apart from the act, the forming act, then we also establish our rules which govern the proceedings, the appointment of arbitrators, and not only arbitrators, we also conduct mediation. But now today we are sticking to arbitration. Probably next time I'll talk about mediation. So in 2015, December of 2015, our rules came into force, the Nairobi Center for International Arbitration Rules, and also the Nairobi Center for International Arbitration Mediation Rules in December of 2015. So the center became operationalized in 2016, and we received our first case in 2017, which was registered, and it proceeded until completion. So if you can count from the first time we received cases at this center is from 2017 to date. And it has been an interesting journey, and probably maybe I'll give an overview of what we do and what it means. And Abayomi had mentioned about institutional arbitration and ad hoc arbitration. Those are different regimes of the practice of arbitration. Under the NCIA, we do institutional arbitration. What does that mean? Institutional arbitration is when you submit your request for arbitration under the NCIA arbitration rules, we proceed and administer the dispute. We foresee the whole process of the dispute at the center. We have case counsels. I'm one of the case counsel at the center. We register your request as a case counsel is admitted, is appointed to your case, and once the arbitration process has proceeded and is continuing, a case counsel ensures that the timelines are met by the parties. If the arbitrators are also compliant with the orders or directions, even the parties are compliant with that. And we also follow up on in terms of payment, because if you look at ad hoc arbitrations, the payments are usually made directly to the arbitrators. But in this particular aspect, the payments are usually paid to the center, and then the center holds the money and transfer it to the arbitrators, and also caters for the services. And if there's any money that is remaining, the monies will be returned to the parties. So that is how we conduct the arbitration here at the center. Institutional arbitration. And just to say, this is the only institutional arbitration. It's the only institute for arbitration in the country like that conducts institutional arbitration. We have the Chartered Institute of Arbitrators, but it conducts ad hoc arbitrations whereby they appoint an arbitrator, and then the arbitrator now will foresee the whole process. When it comes to payments, when it comes to the timelines, when it comes to following up on everything, it's the arbitrator who's in charge of that. So those are the differences probably I'll just want to make. So now, having just mentioned that Kenya is conducts institutional arbitration, probably I just want to talk about what others have said about us before I talk about what we do and how we do it. So we had the SOAS African Arbitration Survey. It's an international organization that conducts surveys of the best practices of arbitration and in Africa in 2020. And this survey ranked Kenya, the NCIA, among the top 5 arbitral centers in Africa, as chosen by the respondents. It also ranked, NCIA ranked among top 5 arbitral centers with the best support facilities, as chosen by the respondents. Now, as I've mentioned, we first received our case in 2017, and we have continued receiving cases from then on to now. The progression has been always upwards since the inception of the center, and also since the receipt of the first case. Let me just mention the 2018-2019 caseload value. The value of the cases that we received were 2.5 billion Kenya shillings, which is equivalent to 25 million USD. In the year 2019-2020, the caseload value was at 7.5 billion, which is equivalent to 70 million USD. 2020-2021, the caseload value was 13 billion, equivalent to 130 million USD. So this is just to show you that every year we're receiving cases that we administer as a center, and we make sure that the timelines for administrations are also within the confines of the rules for arbitration under the NCIA. Probably maybe something that may be of interest to SMEs. You may want to ask yourself, so what kind of arbitration, what industries or sectors file arbitration cases under the NCIA arbitration? I would want to say that so far so good. The majority of cases have been able to register so far and administer have been in the supplies of commodities. But we've also received cases in the construction industry, the transport industry, finance industry. I have not even put another one here, but employment industry as well, in the employment sector. So just to say that we receive a lot of, this is not we are not just limiting this to, this is not the limit of NCIA. This is the majority of cases we've received. The people who have, or organizations that have input the NCIA arbitration clause in their contracts to come to NCIA. So these are the kind of cases we have been seeing so far so good, and we are open to receiving any kind of cases to administer at the NCIA. So as I've just mentioned in my previous slide, we received a lot of cases in construction, supply and demand, and these are the kind of the contract agreement, the NCIA actually agreements that we received in the supply and demand agreements, which shows the higher rate of agreements we have been able to deal with. We have seen also employment agreements and also service agreements. I think I've just talked about this, but I'll just mention again. We have rules that govern the practice of arbitration under the NCIA. Despite having the act, we have the rules. I have just mentioned the NCIA arbitration rules, which came into force in 2015, but amended in 2019. And also NCIA mediation rules, which we'll talk about probably in some other forum. Basically, and then we also have the guidelines on NCIA unilateral administered arbitrations. So what does it mean to have NCIA unilateral administered arbitrations? It means that you have a party, for example, you have a party who has in their contract mentioned that once a dispute arises and we are going to have an arbitration conducted, then the rules that will govern the arbitration process will be the unilateral arbitration rules. So obviously, when you see that, and you're probably you're in Kenya, or you're in Tanzania, you're in Sierra Leone, or anywhere, or Uganda, whatever in this continent, or anywhere in the world, then you may want to think: should I go to London? Should I go to France, to Paris, or should I stay in Africa? Well, probably if you want to stay in Africa, it will be cheaper for you. Then. But my contract talks about unilateral arbitration rules. Then what should I do? So what NCIA has done, NCIA is also an appointing authority under the unilateral arbitration rules, which means it can help you appoint an arbitrator and help you administer your arbitration. And we have guidelines on such a process. So if you have your unilateral arbitration, you don't have to go anywhere. And actually at NCIA recently, we have actually registered our first and actually appointed an arbitrator for our first unilateral administered arbitration under the NCIA. So you will be able to, the arbitration will be administered under the NCIA, but the rules applicable will be UNCITRAL. And as just mentioned before, the NCIA arbitration rules is actually mirrors the UNCITRAL model or UNCITRAL arbitration rules. So really, you'll not find a quite diverse or a different kind of rules that you're using, or a unique kind. Probably just a short diversion, but not really like a big one that would change the outcome of your arbitration. So probably I just want to take you through something that everybody would need to know, like then how do I commence arbitration under the NCIA arbitration rules? Our rules, which can actually easily be found on our website, which is www.ncia.or.ke. You can easily, it's downloadable, so you can actually have it on your computer or your laptop or your phone and be able to go through it. But let me just give you a small overview of how you commence arbitration under the NCIA arbitration rules. So you submit a request for arbitration, and it's done so in writing to the registrar of the center. The registrar is also the CEO of the center. And you also pay the requisite registration fees, which is clearly outlined in our rules. You may also want to know, then what is there a format in writing that I would want to follow when I'm submitting this request for arbitration? It can come in a letter form or whatever structure. You can even want to do it in a tabular form, whatever way you wish. But what would guide you is Rule 5, which will guide you on what is needed on the request for arbitration. And this will be in paragraph 2 onwards of this slide. So the request must include the contact details of each party. So each party is the party who's initiating the arbitration and the party whom the arbitration has been filed against. And then a copy of the contract in which the dispute solution clause is provided. As Abayomi said before, then the contract for arbitration or the contract that stipulates the arbitration or an arbitration agreement must be in writing. Then the dispute resolution clause also must indicate in this sense that once a dispute has arisen, then you will come to NCIA for dispute resolution. So now, then that is the essence of supplying a copy of the contract. Then because for us, we want to see if the dispute resolution clause provided mentioned NCIA as a center of choice. Then also submit a brief statement describing the nature and circumstances of the dispute and the relief you're seeking. How is this helpful? If you're giving a brief statement describing the nature and circumstances of the dispute, then it will also help the center when it comes to the appointment of an arbitrator, and also determine whether it's a complex dispute, because when you are appointing an arbitrator, we're looking at the nature of the transaction, we're looking at the nature and circumstances of the dispute, etc. So if you've been able to clearly and succinctly outline these aspects, then we'll be able to guide you and we'll be able to easily appoint an arbitrator that would be able to solve your dispute in the best way possible. And then also it's best also to indicate the seat and language of arbitration. I don't know if the seat was explained quite well, but seat does not mean really where the arbitration is taking place, like physically, in terms of, you cannot say the seat is Nairobi. If you say the seat is Nairobi, you mean the governing law, the laws of Kenya, of Nairobi, of that country at the applicable law. That means the seat. But the venue is a different kind of description. Venue is Nairobi. Venue means like we'll have our arbitration probably in Hilton Hotel, or we'll have arbitration in Nairobi Center for International Arbitration hearing rooms. So you may have your arbitration conducted in London, but the seat for arbitration is Nairobi, which means the laws of Nairobi will apply to that arbitration. And then you also want to specify the language. You also want to say, okay, we want the arbitration to be conducted in English or in French, in Portuguese, so in Kiswahili, if that's how you want your arbitration to be conducted. So that would mean one thing. if you choose now, because we have a panel of arbitrators we have in our panel. So if you say you want to conduct your arbitration in French, then we have to select an arbitrator. Then we'll want to choose someone who speaks French, or we'll want to choose someone who is agreeable to what the parties have agreed on. As Abayomi had mentioned before, then it is parties decide on the processes of arbitration, the selection of an arbitrator, the language they wish to use, the venue they wish to go to. You can go to a hotel room, you can go to a boardroom, however way you want to conduct this. And also the request might talk about, you know, the procedure for appointing an arbitrator. So and what determines all this is the contract. If the contract had said that we will appoint an arbitrator jointly, or we will appoint we'll choose an arbitrator in this particular manner, then in the request is when the parties will submit this discussion. So after an arbitrator has been appointed, so the process of appointing an arbitrator is different. The first reposition is to the parties. The parties are the ones to appoint an arbitrator. So we give that chance to the parties. Once the request, we have received the full request, the registration fees has been paid. The registration fees is determined by whether the case is a domestic arbitration or it's an international arbitration. So when all this is complied with, the registrar issues a notice of registration to the parties. And once this notice of registration has been given, then the registrar directs the parties to appoint an arbitrator in a manner which they have agreed, or if there's no agreed manner, gives the parties a chance to advise the institution on how they would like an arbitrator to be appointed. Then that is when the proceedings now start. We are given probably like 30 days, but we'd want to also minimize the length of time it takes, because this is where, you know, this is what delays the process, because if the parties are taking longer to agree, then the center the final reposition of appointment is actually to the center, either way. So if the parties are delaying on appointing, then the center will proceed and appoint. And after appoint, so the parties may have agreed maybe to have a 3-member tribunal or a sole arbitrator. But our rules provide the final, the default appointment is a sole arbitrator, unless the parties have agreed otherwise, or unless the center sees the complexity of this dispute and it needs the appointment of 3 arbitrators. As Abayomi had mentioned, the third arbitrator would really come in as a neutral factor, or rather, as a tiebreaker whenever there's a situation where the 2 co-arbitrators have not agreed. So the procedure for appointment for arbitrator, the processes are clearly outlined. If the parties have not agreed, they are clearly outlined under our rules. Once an arbitrator is appointed, then the dispute is assigned to a case counsel, as I previously mentioned, who assists in the collection of documents and ensures the parties are adhering to the tribunal directions. And also the tribunal itself, it's adhering to its directions and the timeline, so that there's no time wasted in the process itself. So I have just explained the way the request is analyzed to make sure that the prerequisites are met, and then an arbitrator is appointed. So then maybe there's one question that we keep receiving, and I think this is the kind of request for arbitration we have been receiving for the past couple of the past year actually, and also in the mediation as well. So what if you have a contract, yes, and it doesn't have an express mention of the NCIA? Then what happens? Then does it mean if I still want to come to NCIA, does it mean that I will not come because my contract clause does not mention NCIA? Maybe it says, whenever a dispute arises, the contract, the dispute will be referred to arbitration under the Kenyan law or the Arbitration Act of 1995. Then obviously that has not chosen a center. When such a contract says so, it means you have to go to court, and then the court to guide you on what happens in your arbitration process. Obviously, the court will not entertain the dispute, but it will refer you to arbitration. But you see, that's a long process. And that brings me to the discussion of it is very important when you're drafting your contracts that your arbitration clauses, or rather your dispute resolution clauses, are very clear of how or where you'll have your dispute administered, or whenever an arbitration case, whenever a dispute arises, how will you go about it? So this is where now we have an open door. We will not chase you away and say, oh, you don't have NCIA and arbitration, you have not mentioned NCIA as your center, then we'll not hear your dispute. No, we'll advise you to amend your dispute resolution clause or come up with a separate agreement. We even have a template that we have prepared. Whenever such a situation happens, we share it to the parties. It's a one-page complex template, which probably mentions a dispute has arisen, and we have agreed that probably party A and party B acknowledge that a dispute has arisen, and for that reason, we are presenting our dispute before the NCIA, and the arbitration will be administered under the NCIA arbitration rules. Both parties sign. So you submit that with your request for arbitration, and we will happily take up your arbitration dispute. Then I have just, the last part of the slide talks about appointment under the UNCITRAL or other rules, which I had just mentioned in my discussion previously, talking about, the guidelines for the NCIA, UNCITRAL administered arbitration, and how the NCIA is an appointing authority. And once we appoint an arbitrator using the UNCITRAL arbitration rules, then we will administer it under the same particular rules. So it's not something that NCIA cannot be able to deal with. Now, what are the default? So now you may want, I think I just mentioned, we have default clauses or default rules of the practice of arbitration under the NCIA rules or the administration of arbitration cases. So if the parties have not agreed on the seat of arbitration, right? And I had explained the seat of arbitration to mean the substantive laws that will govern the dispute, which means maybe you want to say, maybe the contract laws of Kenya will be the one governing dispute. That means the seat of arbitration. So if the parties have not agreed, so first of all, the default is by agreement of parties. If the parties have not agreed, then the seat of arbitration will be Nairobi. And the language of arbitration, we look at the agreed language by the parties, or the default will be English, where there's no determination of such. Appointment is the party choice. Party autonomy, party freedom to choose whom they want. You can decide to choose from our panel of arbitrators. We have a panel of arbitrators. We will be happy to share their resumes, their CVs, whenever you wish, or a list of people that we think would be appropriate for your arbitration, and then you'll be able to choose with the other party. But if the parties have not chosen, then NCIA is the final recourse for appointment of an arbitrator. Now, emergency arbitration, the parties may decide to file an emergency arbitration, which is catered for under the arbitration rules. So that just means you want an arbitration to proceed quickly. That's what it means. You want an arbitrator appointed quickly within a couple of days, and the process to take up quickly, because probably there's a dispute which, should it take longer, then you'll be at risk of losing. Now, the time for award, it's 90 days from the last date of proceedings. The last date of hearings, we advise and require the arbitrators, even upon appointment, that they should agree that once they are appointed, they know that after the last day of hearing, they have 90 days to release the award to the parties. So at the case management department, we have a case tracker, which allows us to collect time management informations. And I think the below trends I'm giving you is the trends we have observed over the years, which indicates, the average time scale we have been able to do stuff. So typically our requirement is to have 7 to 10 days for the appointment of an arbitrator and complete composition of a tribunal. As I had mentioned earlier, once we have received a complete request for arbitration, then the parties are the ones who are at liberty to select an arbitrator. They're given 30 days to do that. So the earlier the parties decide on an arbitrator, then the better. But if the parties will not have agreed on an arbitrator, then the center will be the one taking that position of appointing one. Then we take it up to ourselves 7 to 10 days to appoint an arbitrator. And what happens between that 7 and 10 days? We have a pool of arbitrators in our panel. Sometimes they are conflicted with the parties who have been presented before us for arbitration. So we need to actually first, we actually send a nomination letter to them and ask them, are you available for this? We have a dispute before us between this and these parties. We don't mention the contents of the dispute. We just probably maybe on a contractual claim between two and these parties. Please mention if you have any conflict of interest. Do you know this party? Have you appeared before them before? Have you worked before with them before? Have you represented them, one of the parties? So that you may be conflicted to sit as an arbitrator. And we give them about 3 to 4 days or 5 days to respond to that request. And then after they have responded in positive or in the negative, then we will proceed to appoint. That hence my mention of the 7 to 10 days to appoint a tribunal, because we have to make sure that there's no conflict of interest between the parties. And in this circumstance is when the parties have not agreed and the repose now is on the center to appoint. But the parties are usually given at least 30 days. But 30 days does not mean that you take up the whole 30 days to appoint an arbitrator. You might appoint within 2 days if both of you have agreed. And then we talk about 5 to 7 days of actual appearance of hearing before the arbitral tribunal. What does this mean? It means that once the initial filings have been placed, probably the preliminary hearing is usually probably a day to agree on the timelines, to agree on the procedures of the tribunal, procedures of the arbitration itself. Then after that, then timelines are set by the tribunal. Like you have 15 days to submit your statement of claim. After that, the respondent has another 15 days to submit the response. And then another maybe 15 days to submit a response to another response. After that, now, after all these documents have been submitted, then the arbitration is set up for hearing. A hearing, sometimes arbitrators can decide, let's take 2 full days of hearing. Let's take Tuesday and Wednesday from 9 a.m. to 5 p.m. to have the case heard, and 2 days. So that explains why I'm saying 5 to 7 days, because the first day would have been the preliminary hearing. The second day would have been the first day of hearing. The third day would be the other day of hearing, maybe another 2 additional days. And then that's how the 5 to 7 days occur. But you may wonder why sometimes these cases may take long. You find that, a tribunal cannot proceed to full hearing if there are preliminary objections. If the parties have an issue maybe with the jurisdiction of the tribunal, they say the tribunal doesn't have jurisdiction or the power to hear this case. So now what happens? The tribunal has the power to determine whether it has jurisdiction or not. It doesn't mean that they have to go to court to determine first. That is the aspect that Abayomi had explained earlier, and I have talked about it before. Competence. The tribunal has the competence to determine whether it has jurisdiction to hear a dispute or not. And if you're not satisfied, then you can take it to court, but the tribunal has the first authority to determine that. So if you see parties submitting preliminary objections, or maybe objecting to production of a document, objecting to particular proceeding or production or a witness or testifying on a case, then that's what delays the process. That's what lengthens the process. You find out the process, or even parties not keeping timelines. If you're given 15 days maybe to submit your statement of claim, and then you're extending it to, now you're asking for, tribunal will be happy to extend it, but you see you're delaying the whole process in itself. The tribunal will be happy to extend your timelines. Maybe you submit with maybe 3 more extra days or 5 days, but now you find yourself now moving. Obviously, if you're getting 20 days, then why is it? Then the respondent will also ask for 20 days, or well, the respondent might maintain the 15 days, but he will have the right to ask for more days. So you see, The parties also need to be very vigilant when it comes to keeping the timeline so that the arbitration process can become shorter. So as of 50 or 150 days to the exchange of pleadings and, preliminary scheduling and timelines I have just mentioned, this is what lengthens the whole process itself. And 1 to 1.5 months of completion of an award, as I had mentioned, 90 days, which is actually very much so. That is the timelines we've been able to keep at the NCIA. Now, we have also, after the award has been submitted, the award will be submitted to the party within 3 to 5 days. Now, this is where the problem comes in. When you conduct even if it's ad hoc arbitration, once an award is issued, if the parties have not paid the charges, maybe the required, you're not cleared your balance, maybe the payments for the arbitration processes, probably the administration costs and arbitrators' fees. If you have not been able to submit those payments, then you will not be able to pick your award. That's what happens at the center, because now you see we are not able to execute the payments. We're not able to execute that. That is our only security, the award that we have. So if you're not able to pay up what is required, then we'll be at an unfortunate position to hold the award until the parties are paid. And that's what delays. You might find an award that is dated maybe December. But now, because the parties have delayed in the making of the payments, then as soon as we receive the complete payment, even if it's today, even if it has stayed for 2 months, we will notify the parties to come and pick the award. So probably one of the advice, if you're taking the route of arbitration, once the award is out and this final statement of accounts has been issued to the parties, it is prudent for the parties to pay on time so that they can be able to pick up the award and follow the enforcement mechanisms that are available to you. Now, arbitration fees. At the center, we provide that the parties are jointly and severally liable for the arbitration tribunal and the center's administration costs. What does it mean when you say jointly and severally liable? Jointly and several liability, it means both of you are liable. We don't say, oh, yes, maybe the shares that we expect from the parties are divided in equal shares. But when it comes to the payment of the arbitration process, we expect the parties to make sure that the payments are made. So if at one point, maybe the claimant, the person who initiated the arbitration process, has paid their share and the respondent has not paid their share. Let me give you an example of a recently released award that we have had. So this award was ready a couple of months back, and then once the award was issued, we issued the final statement of accounts requiring the parties to pay in equal shares. They had already paid the initial deposits. The claimant paid their share on time. As soon as we notified them of the award today, tomorrow, they had already paid their share. But the respondent hadn't paid their share. Now we cannot issue, just because the claimant has paid its share, we cannot issue out the award because we have no way of following up on the payments after that. Once we release the awards, we have no way of doing that. And we cannot, because we respect the autonomy of the parties. We don't want to go to court and follow up on the fees and all that. So our security is the award. So because of that, we had to hold the award for a while. And the respondent, the claimant saw that, there's a delay. There's a delay in the payments by the respondent. And because the parties are jointly and severally liable, the claimant is under the obligation to pay so that he or she can be able to collect the award. So the claimant paid the respondent's share. So she was able to collect the award. And once they collect the award, you can actually go to court and enforce and show proof that I paid their share. So you get the monies that were determined by the tribunal and the extra money you have paid for their share. And the court can be able to recognize that. So when it comes to registration, let me just give you like an overview of the registration fees. For domestic arbitration, when you're filing domestic arbitration, is 10,000 shillings. And if you have an international arbitration, it's $100 plus one to the first schedule. $100 probably equally the same kind of, with the same, almost the same amount with the domestic arbitration fees. So Maybe the question you'd want to ask yourself then, what is domestic? What is considered domestic? Then what is considered international arbitration? What is considered domestic here is a dispute between two parties who are Kenyans. Two parties may mean two persons or two companies which have been registered in Kenya. International arbitration basically mean maybe a Kenyan corporate and a Sierra Leone corporate or a Tanzanian corporate. Or international arbitration can also mean a dispute between a Tanzanian and a Ugandan, but you want to use the NCIA arbitration rules. Those are the kind of circumstances that we recognize as, either domestic or international arbitration. And the appointment of arbitrators now. So I think I have really dealt with this in my previous discussions, but just basically the Rule 7 of our rules discusses about, the appointment processes, if it's one arbitrator or it's three arbitrators, but the parties reserve the right to nominate. Basically, the parties reserve the right to nominate an arbitrator, but the final repose of appointment is the center, and also when the parties have not agreed on an arbitrator, whether it's a three-panel arbitrator, a three-panel tribunal, or a sole arbitrator. So just a little bit of numericals about what we have done so far. So during the course of 2020-2021, we have completed a total of 15 appointments, which has always represented an increase, because every year we have received a lot of an increase of registration of arbitration cases. So this showed a 10% increase from the previous year, which saw 14 appointments. And when it comes to, we receive on a rolling basis accreditation requests for people who want to join our panel of arbitrators. If you want to join our panel to be an arbitrator or a mediator, you apply to a center on a rolling basis. You can apply. I mean, we don't have like an application window. You apply to express your interest, so long as you qualify according to the guidelines that you've provided, which can be easily accessed on our website. So in that financial year, we received 23 accreditations. So when it comes to the appointment of an arbitrator, we are very keen to recognize that we receive both domestic and international arbitration cases. So hence, that's why we ensure to promote, diversity and neutrality and, numerosity in the fields of practice these arbitrators coming from, whether they're engineers, they're architects, they are lawyers, they are accountants. We have all of them in our panel. So we have the impaneled arbitrators from different nationalities, and arbitration selection of our panel is undertaken throughout the year. And the criteria that we use is actually a very intensive criteria. You submit your application. It is first placed. We receive it at the case management department or at the center, and then it is presented to a committee, which is formed by some few members of the board. We're able to assess your application in relation to the guidelines we've given to people who can join our membership. And then once that step has been completed, then it is submitted now to the board, the full board itself, which approves the appointment of an arbitrator. So, and this board is a neutral. It's a board that is. We get the board members from all areas of practice, from both the private sector and the public sector. Even the SMEs are well represented in the board. So we want to make sure that the people we appoint in our membership, or people who form a list of our arbitrators or mediators, are well qualified, so that when parties present their cases before us, we're able to appoint an arbitrator who's well qualified to handle a particular dispute. Well, in as much as we have, a diverse and neutral arena of arbitrators, then it's good to note that Kenyans take about 75% of our membership, stemming from the location of the center. The center is located in Nairobi, it's in Kenya, then we'll definitely be having more Kenyans. But that's not to mean that we don't have a lot of arbitrators from all other countries. We have arbitrators from Europe, the Americas, all of the Asia, in Africa. So we have arbitrators stemming from every part of this continent. So and so and also in different ages. We have from, you know, the as young as you can imagine, and as old as you can imagine. So Abayomi had just spoken about the COVID-19 pandemic and how it has affected, you know, the practice of arbitration. And the center adopted and ratified virtual hearing guidelines, thankfully to the African Arbitration Academy, guided by our own Abayomi here. They had laid the foundation for, you know, the creation of these guidelines to be, you know, featured or you know, cater for the African need. And as a center, we saw that this, once we got a hold of the guidelines, we're able to look at it, and we actually saw the need to broaden our framework and actually realize that, you know, we're going virtual right now, and we need to also guide the practice of arbitration virtually. And that, so far so good. We've had our arbitration cases taking off even during the COVID-19 pandemic has been going. So parties are allowed to choose whether they want to proceed virtually or they want to meet physically. We provide for such platforms. We have internet facilities, we have hearing room facilities at the center. You may be able to look at all of that on our website, and actually the rates that we offer for our hearing room facilities are very affordable, and that's one of the shares for the administrative costs. The administrative cost is it's very sensible at the center, because what we charge is 1.5% of the arbitrator's fees and what you've used as the hearing facilities. So if you're here in Kenya, maybe you're coming here maybe for 10 people, then we will charge you like about 10 to 15,000 a day, depending on the number of people who are coming, and we provide refreshments and all that. So what we do is we like to make the arbitration process as seamless as possible. We would like to make it as affordable and accessible as possible. And apart from that, we actually focus on confidentiality of the cases that we receive here. I don't think you'll hear of any cases that have been filed here from myself or from anyone at the center, unless the parties have filed the same before court and it's in the public limelight. And I think that's one of the things that most SMEs you would want to focus on, is to protect their reputation and also focus on you know, ensuring that their disputes are well administered and well solved. And at the NCIA, that's one of the things that we make sure that we offer the parties. I think I have really given an overview about the practice of arbitration, and NCIA. Probably I'll want to look at the Q&A and answer a few questions the participants may have. I've seen a question here from Emma Wanjiru. She says, I wonder if it's okay for an individual SME to make a courtesy call to your office. Yes, for sure. Our office is an open door policy. Feel free to visit our offices if you need to have more guidance about the practice of arbitration, about how to include our clauses in your contracts, about how that process would entail. We are happy to answer your questions. You'll find me, you'll find my co-case counsels, you'll find our CEO, so we'll be happy to do that. There's another question. Someone is asking me to kindly repeat the difference between NCIA and NCIA. I really didn't understand what you meant by institutional and ad hoc. So there are two systems of administration of disputes in arbitration. There's institutional and then there's ad hoc. Institutional means that the case is filed, or rather filed, let me just use the word file, but that's not the right word, but filed in an institution like this. Institutional administrative arbitration is they take charge of your case. They follow through your case. They once a case is filed, a case counsel is administered. All the hearings, the case counsel attends all the hearings. If they want to provide for stenography services, the institution does that. When it comes to communication between the parties and the arbitrator, it's through the center. So the parties send the documents to the center. We send it to the party, to arbitrator, and vice versa. The parties, the arbitrator sends the documents to the center and to the parties as well. So, and then when it comes to receipt of money, like maybe money regarding to the admission of the dispute, the money is paid to the center, and then the center is the one that pays out to the arbitrator and also to the parties if there's any refunds to be made. So institutional really, it means that the arbitration itself is not really guided by the parties and generally and the arbitrator, but governed by the procedures of the institution. When it comes to ad hoc, the institution itself, like for example, let me give CIAB Kenya. You file your case. Maybe the contract talks about when a dispute arises, the matters will be administered under CIAB arbitration rules. Once you go ahead to CIAB, and then the CIAB they appoint an arbitrator, and that's where their mandate ends. Once their mandate ends, then the arbitrator now takes charge of the case. The arbitrator and the parties will now determine where to hold their cases. It might be CIAB, it might be at NCIA, it might be anywhere else. And when it comes to the payment of the arbitral cost, you pay directly to the arbitrator. So it's like an agreement between the arbitrator and the parties. Probably another difference would be that and then once the award is issued, you issue it directly to the parties. So the agreement is between the arbitrators and the parties. But now here there's a third party. In institution, there's a third party who oversees the whole process. I hope I've explained myself well. I've seen another question of what is the role of a case counsel. Maybe just to say it again, a case counsel is appointed to a case so that to make sure that all the timelines are met, both by the tribunal and the parties. If the tribunal gave a direction for filing of statement of claim within 15 days. Before the end of the 15 days, the case counsel is obligated to to remind the parties, where are we? Have you filed this? Or if there's there's money needed to be paid, the case counsel will also follow up with the parties that we need to deposit this amount for the tribunal for the arbitral case to continue. Or if the tribunal is supposed to issue an award within the 90 days, then as at the 60 days, the council is supposed to ask the tribunal, where are we with the arbitration or with the award? And even if the award has been issued, the council has to go through the award before it's released to the parties, because maybe there are typographical errors or anything, or even there are changes that maybe the tribunal may have overlooked. So maybe there was something that was agreed, maybe an example in the order for directions. After every hearings, the tribunal usually gives the order for direction, what comes next, what proceedings should follow. So when a case counsel has attended a particular arbitration hearing and an order for direction has come out, and there's something that was discussed and has not been captured by the order for directions, then it is the obligation for the case counsel to direct or guide the tribunal on compliance with this, with what they had mentioned when the arbitration proceedings were happening. So the role of a case counsel is wide. Apart from guiding the tribunal, also we do. Sorry.
Oh, okay. Okay. All right, you can go ahead, Victor.
Okay. Yes. I'm seeing another question. What causes the parties not to pay their fees? Are there any factors? For me, I feel like I think parties, once you delay the cases, as I mentioned before, you keep delaying the case. That means more charges to the arbitration process. So if you end up finding you have a higher charges, then you will find yourself not wanting or not willing to pay because you don't have the finances. But some people don't pay because maybe they want to frustrate the process. Sometimes that happens. It happens maybe the one party knows, if I don't pay, then I know the arbitration is not continue. So you put the other person in jeopardy because the arbitration process might be stalling because of the non-payment. And then the other party will be forced to pay on your behalf so that the process can continue. So I think it's in good faith once you know that you have an arbitration process coming ahead of you, then, and you've already appeared before the tribunal, I think it's in good faith for both parties to also be able to cater for the fees that are applicable in your particular case. Mm-hmm. Someone is asking, have you guys handled any entertainment cases so far? So far, so good, we haven't, but we'll be happy to handle it once you submit the case to us. Definitely, we will not find it hard to administer such a case. Are the costs for the services fixed? So the costs for the services are fixed, but now it depends on how long the parties would want to take to ensure to continue with the processes. So for example, now the cost for an arbitrator fees depends on the case. So, but the maximum amount we can charge is 25,000 an hour, 25,000 Kenyan shillings an hour. This is approximately about $250 for domestic arbitration. It's a different rate for international arbitration, which you can actually easily find in our rules. So if, for example, you file a lot of preliminary objections, obviously the tribunal will have to sit to hear that preliminary objection. The tribunal will have to write an award on that preliminary objection. That means there's more time that is wasted. So if you're filing these objections early on to frustrate the process, then you're really frustrating yourself financially. So you have to choose your battles. You have to choose whether am I willing to lose a particular amount of money because I want to frustrate the process. But if you really focus on, I want to meet the timelines, I'm given 15 days. We have agreed on hearing for 3 days, we meet on that. Then the prices will depend on the number of days the arbitration takes place. I've seen another question. In a normal circumstance, arbitration seems to be cheaper than normal court proceedings. On the other hand, arbitration is more expensive. When hiring an arbitrator, mostly of them are expected to be paid hourly according to the agreed amount. How is this relevant? True. So that is why I was telling you about the administered arbitration in particular. Actually, this is another aspect of institutional arbitration, because you already have specific rates that will apply to arbitrators. And if the arbitrator, once they are appointed, they are not agreeable to that, then I don't think they'll be able to take up the case. When it comes to ad hoc, the different arbitrators will charge different amounts. They'll say, I have 30 years of experience and I would require maybe 40,000 an hour or $400 an hour. Then because it's ad hoc and there's no rules that would limit this application of these fees, then you'll end up paying that much. But when you're coming under the institutional arbitration rules under the NCIA, the maximum they can be able to charge me per hour is 25,000. But for example, if there's a tribunal of 3 members, we'll not charge 25,000 an hour for each arbitrator. Probably we'll have the chairman of the tribunal charge him about 20,000 an hour, and 15,000 and 15,000 for the other co-arbitrators. So what also determines how much we're paying the arbitrator is the value of the case. We'll not be able to charge a lot of, for example, the case is the value of the case, maybe what you're asking for is 4 million Kenya shillings. Really, it will be very unfair to the parties to charge them the high maximum rate of 25,000 an hour. We would probably look at charging the case at 15,000 an hour, so that at least the parties will not be able to pay, administrative costs or arbitrage fees only and probably if you're getting maybe little monies from the award that has been given. So the tribunal, the registrar and the CEO, we also look at those things that would encompass the appointment of an arbitrator. So it's not really like, oh, this is an accounting problem, we are looking for an accountant. No, that is not the only thing that we look at. We look at a whole myriad of factors. Another question I'm seeing, the normal agreement between the parties of the case to their case without including an arbitrator, does it, I don't think I can understand this, but let me just look at it again. Their case without including an arbitrator, does this can be followed under ADR and the agreements become enforceable in court where proceedings took place? I'm sorry, Ikomo, I could not understand your question. Probably you can rephrase it and type it down there. I'll look at it in a few. Sarah Mbasha has asked, is Nairobi Center for Arbitration a government institute? Yes, it is a government institute. And this is the question that I know the question that comes thereafter, what is it is, and I will just gladly answer before it is asked. So it is a government institution, and you may want to ask yourself, okay, if it is a government institution, does it mean that the government interferes with, the arbitration? Does it interfere with the awards? How sure am I that I will go there? Maybe I'm suing the government, maybe a government institution, and then I'm taking it to arbitration under the NCIA. Will I get a fair award, or will they be influenced? So number one, the tribunal members, or the members who have joined our panel, are independent people in the practice of arbitration. This means that we do not, select people from anywhere. You apply independently. Sometimes we don't even know you, and then your application is approved by the two-pronged test I had just mentioned. The board members are independently selected from the private and the public sector, minimally public sector, but mostly private sector, who are well-qualified arbitrators, who are well-qualified practitioners who will be able to hear your dispute. And to answer probably a question that may emanate, we have received a lot of cases against the governmental institutions in Kenya. And we've seen a number of them actually losing these cases against private sectors or SMEs that have filed these disputes at NCIA, which means that there's no unfairness, or there's no, because you're a government institution, then there's favoritism because you're government, then we don't want to strain the other. No, there's no particular influence to that effect. Someone is asking, can you seek to rename the center to include mediation, say arbitration and ADR, because always sound restrictive yet inclusive of mediation? Probably that would be something. I understand where you're coming from, but the reasoning behind the naming of Nairobi Center for International Arbitration, despite the fact that we cater for mediation, actually we have received a lot of mediation cases in the past year. Most centers are formed under, you say Nairobi Center for International Arbitration, despite the fact that it caters, even if you see the act, it talks about, will administer mediation and arbitration. And the naming of this institution, you can see it, many countries like Mauritius International Arbitration Center, despite they might cater for arbitration, or Singapore International Arbitration Center. So the practice has been, you set a center with the name of arbitration in the location that it has been created. So Nairobi now becomes the location of where the center will be, then we choose it as Nairobi. And someone else was asking, why can't you say Kenya in arbitration and mediation? Why do you want to say Nairobi? Why do you want to stick to Nairobi yet you are catering for the whole country? So that is probably the reasoning behind most of these centers, the naming of these centers. I hope I've answered that question, but it's something to think about if it's maybe what the majority of people have are having, a concern about. Now, another question is, can a judge act as an arbitrator? In the past, judges could act as arbitrators, but now with the aspect of conflict of interest, then you would not want to appoint a sitting judge, because the case he might be administer the case here, and then the case is presented in the judiciary, and then he's the one sitting on the same dispute. So how will that happen? Obviously, they will recuse themselves from sitting from that case, but you don't want to create such positions. So what we usually do, like if there was a former judge, and then he applies to be on our panel, then a former judge can be an arbitrator, because at that point he's a neutral party. But at this point, we have not had situation whereby judges act as arbitrators, or there's no law that provides for such. Then another question, very good question actually. Will the arbitration agreement still subsist if it includes another ADR method, example, mediation? We have several tiers of dispute resolution mechanisms that you can put in your contract. You can say, once a dispute has arisen, start with negotiation. And then if negotiations fail, then you go to mediation. If mediation fails, it goes to arbitration. So you'll follow the procedures that you have put. You'll start with negotiations. If they have failed, you'll start with arbitration. And we've had actually such cases in our center, whereby the contract says whenever a dispute will arise, the dispute will be administered at NCIA. But first, we start with mediation. And we've had such circumstances whereby the parties have come, they have tried mediation under our rules. They tried to negotiate, it didn't work. And once that mediation flops, then they proceed to arbitration under our rules. So you can actually, the arbitration agreement will still subsist, and you can actually continue, you can follow the processes as you put in your agreement. In case the parties have refused to pay your costs and they go and agree between themselves, how do you go about it? Because definitely they will not need the award. Yes, that is so now that is where the problem has come in. If the parties now have agreed and have gone and we have no cost on our end, then that's where the problem comes in. That's why before the parties, at least before we continue so deeply into the process, we urge the parties to pay the cost, because you don't want to also waste the time of the arbitrator to continue hearing the dispute, and then at the end of it, the parties have agreed, and then the tribunal has not been sorted. Now that would mean we go to our pockets, because it's hard for us to really enforce in terms of probably filing a case in court or following up with the parties. We expect when the parties are coming to the center, they're coming in good faith, that we help in the administration of disputes, and also they also cater for the arbitration costs. There's a question: have you handled cases in the transport, logistics, and supply chain sectors, and what are the main contentious issues? Yes, we have handled such cases, particularly maybe I can just mention supply chain. Maybe there's a private sector and a public institution. There was a contract on supply of a particular commodity, and then when that commodity was supplied, it was not paid for by one of the sectors, and then there was a contract, obviously, and the dispute has arisen, and the dispute has mentioned NCIA as its center of choice. Then those are the kind of cases we've received so far. When it comes to transport, also we have received that, but we also mostly in the transportation between, there's a contract for transportation of particular kind of goods, and the goods did not reach the destination, or this transport was not adequately provided for, and there was a contract between the parties. It is filed at the center, and we actually are able to administer. And then there's another question: do the parties during the process would know that they have lost the case? Not really, because during the process of arbitration, you are presenting your case before a tribunal, whether it's a sole arbitrator or is a 3-member panel. And once you submit all your documents, the tribunal goes to review your documents and also review your oral testimony, if you are agreed to have an oral testimony in your case, and they issue an award. So there's really, I don't think you can be able to say, because it's really depending on how you present your case, and also the weight of the case and the facts that have been provided for the tribunal. Someone is asking, where can one train as a mediator or an arbitrator if one is not a lawyer? Just to mention, also NCIA offers training facilities. We train arbitrators and mediators, and we also have CIAB Kenya also doing the training. I think African Arbitration Academy also does the training as well. So you have a lot of opportunities to be trained. If you're intending to have the training conducted at the NCIA, feel free to visit our offices or send us an email, and we'll be able to answer all your questions on training. What role do you think ADR will play in resolving task dispute? Actually, We, for example, let me just mention KRA. They have they actually have a department of ADR when it comes to solving the disputes on tax matters. And I think it's very best, particularly, when you do ADR, you focus on saving face, you focus on, confidentiality, on privacy. So you don't want, because when the case has been filed in court, everyone will know, because court is a public arena. So once your case has been filed in a public arena, everybody will know about your tax issues. So you would want to focus on solving your issues privately when it comes to tax dispute, which is a very delicate matter. Do you handle political mediation, arbitration, and what is the frequency of such cases? We do not really engage in we have not really engaged in the political arena yet. And actually that is usually governed by a different kind of law, particularly in the Kenyan law, when it comes to politics, because you don't want to get yourself in that arena as at this point. Do you have the opportunity in Sierra Leone? So when it comes to Sierra Leone, if you have a contract and you want to put the NCIA arbitration clauses, it will fall under the international arbitration, and we'll be happy to administer your dispute whenever you file the same with us. Where parties start, a good question actually by a member, where parties start with the negotiation and fail and then go to arbitration, do they appear before the same panel at payment effected at each stage? So they don't appear before the same panel. So if you start with the negotiation and then you go now, the next step maybe is mediation. Then in the mediation, the parties now, these are different. Negotiation will not happen here at the NCIA. You will start here at the NCIA and mediation. So the parties will cater for the fees for the mediation process separately, because that's a different procedure. And the panel that will have been appointed in mediation will be what the parties will have agreed on. So if the parties agree after the mediation has failed, and that person who had been appointed and mediator is also an arbitrator, and parties like the way this mediator has conducted the mediation process, and they would still want to appoint him as an arbitrator, they can go ahead and jointly appoint this person as an arbitrator. But if the parties wish to appoint an arbitrator following the appointment process at the NCIA, or if they have agreed on something else, then you can appoint a different person. But payments are effected differently at each stage of the processes you have mentioned. There's another question I've seen here. Does it mean that in an arbitration clause, one has to indicate if it is local or international mediation? Not really, you don't have to do that. So you just mentioned that because you don't know, you see, when you're drafting this agreement, you have not anticipated a dispute. So you just have to mention that once a dispute arises, this is where we are going. Maybe we'll administer this case under the NCIA arbitration rules. Probably I'll just share with you shortly, maybe one of the clause that we have at NCIA that you may want to consider, which is still in our rules. You can actually easily access it on our website, but I'll just share it on the screen, so just for the benefit of the parties to see what kind of clause that we expect at the NCIA. How can you arbitrate matters that deal with two state parties with divergent jurisdiction? Thank you so much for this question. This actually is a dispute. It's called investment arbitration. And what we administer here mostly is commercial arbitration. Commercial arbitration is between, private parties. But now here you're speaking about state parties, which is usually administered under ICSID. At NCIA, we have not yet provided that mandate to ourselves to administer investment arbitration yet. But this is administered under an organization under the World Bank umbrella called ICSID, and which administers dispute between different parties and other organizations, ICC and all that. But NCIA not yet. So far, so good.
Sorry to interrupt, Victoria.
Yes.
You might want to just answer one more question because of
yes.
time. Yeah, thank you.
Yeah, thank you so much. Actually, I think I've answered majority of the questions.
You can share the information that you want.
Yeah, let me just share the information that I wanted to. So this is what I wanted to share, the arbitration clauses, which is found in the second schedule of our rules. So the part that is bolded, it says any dispute, controversy, or claiming arising out of or in connection to this contract or breach, termination, or invalidity thereof shall be settled by arbitration in accordance with the Nairobi Center for International Arbitration Rules. So you can just cut this part and paste it in your contract if you would wish to have your dispute whenever it would have a reason to be governed by the NCIA arbitration rules. And yeah, I think that's pretty much what I had mentioned. And if you have a dispute already at hand and NCIA arbitration rules have not been incorporated into your contract, then you may want to feel free to contact our offices and we'll be able to provide you with a sample agreement that the parties can freshly agree on. Or you can create your own and saying that you want your dispute conducted under the NCIA arbitration rules. I think at this point, I'm thankful. I hope I have answered majority of everybody's questions. And thank you so much for this opportunity, for this training. And we look forward to many more trainings together. Thank you.